Hello and welcome to Macros with Mythili, the ET Now show that takes a hard look at all the major macroeconomic issues and developments in India and overseas. Well, at times like now, when the eyes of the entire nation are on the Lok Sabha elections, it's hard to focus on things like the Reserve Bank of India's Feb 12 circular that seems so far removed from the much bigger issue of who will form the next government. The reality, however, is that regardless of which party comes to power, the routine business of government, regulation, etc. has to go on. Hence, this discussion on the RBI's Feb 12 circular that redefined the relationship between banks and defaulting borrowers. In his press conference following the release of the RBI's monetary policy statement on the 4th of April, Governor Shaktikanta Das was careful to say that the Supreme Court ruling declaring the bank's circular ultra-virus has not really taken away any of the RBI's powers. Rather, it has only struck down the modalities of how these powers are exercised. To quote Governor Das, the ruling mandates RBI to exercise the powers under Section 35AA in respect of specific defaults by specific debtors. That may be so, but since the apex court struck down the circular in toto, the RBI will have to reword its circular such that there is no scope for any further litigation. And the very welcome discipline brought about by the Bankruptcy Code is not diluted. So how should it go about it? Joining me in the discussion are two experts, R. Gandhi, former Deputy Governor, Reserve Bank of India, and Alok Dheer, the noted Delhi-based lawyer who's been closely involved with the Bankruptcy Code. Welcome to the show, Mr. Gandhi, Alok. Let me start by asking both of you, do you agree with Governor Das that the SC has objected to only one clause in the circular, and if that is amended to bring it in line with Section 35AA, the rest of the circular will not be contested or struck down by courts? Let me start with you, Mr. Gandhi. We'll come to the details a little later in the discussion, but for now, I just want your opinion on whether this is the only problematic clause. Mr. Gandhi?
Yeah, that's correct. I agree with the Governor's comment that what Supreme Court has mentioned in its judgment is about the process which Reserve Bank followed while drafting this circular or while issuing this circular. Because under Section 35AA or 35AB, when it comes to insolvency proceedings, these two provisions get precedence over 35A, which Reserve Bank had all along. So that in this circular, the Reserve Bank had mentioned that it has been drafted under the powers given to it under 35A, 35AA, and 35AB. So if you separate that, and I would definitely think that the revised circular taking care of the comments given by the Supreme Court, it should be through.
Alok, would you agree that it's only the modalities of how the reference was to be made that is not in conformity with 35AA? That is the only clause in the circular that could possibly be taken up for litigation again. Alok?
To my mind, I think Mr. Shaktikanta Das and Mr. Gandhi are both right. The critical issue here is 35AA, and 35AA mandates that the central government will authorize the RBI in specific cases with respect to specific defaults for those entities, corporate debtors, to be taken into IBC. The RBI does have general powers under 35A and 21, but it has been clarified by the Supreme Court that with the amendment of the Reserve Bank of India Act and 35AA coming in with respect to cases under IBC, 35AA holds supreme, and it is the central government which has to authorize the RBI or direct the RBI, and therefore the general powers of RBI under 35A and Section 21 of the RBI Act can be utilized for cases other than IBC. And for IBC cases, it will have to be the approval of the central government. So the process will have to be followed.
But Mr. Gandhi, so does it seem as if the root of the problem really lies with Section 35AA rather than with the circular itself? To my mind, while the RBI perhaps is guilty, quote unquote, of not taking sufficient care while drafting the circular, the problem really lies with Section 35AA, since it gives undue power to the union government to interfere in an area that is not really in its domain at all. It is in the bank's domain, and ideally even the RBI should stay out, except that given the ground realities in India, banks hesitate to take on powerful borrowers and refer them to the NCLT. Mr. Gandhi?
See, the point is about taking to IBC is a different one as compared to dealing with or restructuring a loan which is under default. So Reserve Bank definitely has powers under 35A for giving appropriate instructions to the banks how to deal with loans which are on default. Whether that should be taken to IBC, that's where the matter got been brought to Supreme Court, and Supreme Court said that in matters relating to IBC 35AA, because 35AA gives a specific power to Reserve Bank which items or which accounts can be taken to IBC, that it has to be started from the government. So that process will get precedence over general power which Reserve Bank has got under 35A. Whether in this whole arrangement, whether your question that by this arrangement, whether Reserve Bank's autonomy or Reserve Bank's power is being curtailed, that we cannot come to that conclusion so quickly, because it is a rare case of extreme individual cases. It is the government is supposed to give directions under 35AA. So the rest of the matter with regard to generic instruction to the banks, or by even in individual cases, Reserve Bank can deal with under 35A, so long as it is not directing the banks to take it to IBC. So by short of IBC process, whatever needs to be done, that Reserve Bank has full powers.
Alok, do you agree that in trying to solve one problem, we have perhaps in our usual fashion created a larger one? Because much of the problem in the banking space is precisely because of government interference, and Section 35AA as it stands opens the floodgates to more such interference.
Mythili, to my mind, the promulgation of 35AA itself was completely unnecessary. The RBI did have the powers, as Mr. Gandhi has very rightly pointed out, under 35A, and it could have passed directions on case-to-case basis, or even in some sense to a certain extent in generality. The problem has arisen when 35AA got promulgated, because 35AA specifically talked in terms of the government giving the authorization to RBI and also referred to the cases under the IBC. So the Supreme Court said that when there is a specific provision now, 35AA is a specific provision, the power that you had generally under 35A is no more available to you insofar as IBC, Insolvency Bankruptcy Code cases is concerned. So if 35AA was to go away altogether, then clearly within 35A, the RBI has specific powers, and whether it is specific cases or generality of cases, RBI could always have referred them. So to make the things clearer, they've ended up, as they say, muddying the waters.
Mr. Gandhi, amending the law is much more difficult than amending a circular. The need of the hour, therefore, is to amend the circular, and speedily, so that apart from dropping the clause in the circular that gives generic power to RBI, which are the other clauses that the RBI needs to reconsider really, so that it is not caught red-faced again and the circular is upheld in the courts?
Yeah, under 35A, Reserve Bank has got discretion. Whereas under 35AA, when the government gives such an advice or direction, Reserve Bank is bound to do it. So that's the difference between 35A and 35AA. That's why I understood all along until now, when the Supreme Court has said that it is not that in matters relating to IBC exclusively, it is 35AA which will apply and not 35A. That I wanted to clarify that. And now the question that you asked is about. Sorry, I lost track of it.
No, any other clauses in the circular which you think need to be reworked?
Oh, okay. And the provisions of the circulars, the February 12 circular, which it is just a combination of the earlier various schemes the Reserve Bank had introduced, like the CDR or S4A and SDR, and kind of they're combined one. And there, if anything will have to be reworked, certain classes which were kind of impractical. In practice, it has come to notice that may have to be modified, like 100% approval of all the creditors. That is really impractical. So there is a bank, if it is going to redraft, that point may have to be considered again. And about the another area will be the SEBI-related arrangements, which was in this circular, that SEBI has modified its position recently. That's what I understand. So that also may have to be needed to be corrected. So that way, here and there, I would expect as a bank would be realistic about certain provisions which are not practical, and that may have to be modified now.
Okay. Alok, are there any other clauses apart from the two that Mr. Gandhi mentioned that you think needs to be reworked in the circular? We'll go into the details a little later, but very briefly, one or two clauses that you think perhaps the RBI needs to reconsider so to avoid any kind of possible further litigation. Alok?
Yeah, I think, I mean, we'll of course go into the circular in detail as you are saying, so I'll refrain from getting into that at this stage. But the real issue there is 100% is the consent which is required. Incidentally, that is the 100% consent which is required for resolution plans to be formulated by the banks prior to the end of the 180-day period. So once there is a default, they have 180 days to cure this by way of formulating a resolution plan. If such a resolution plan has to be fulfilled, it has 3 or 4 conditions that must be fulfilled so that the resolution plan is treated to have been implemented. One is that it has to be with consent of all. The word 100% is not written in the circular, but the word written there is all, and therefore it means 100% all the people. The second issue which has been troubling some of the borrowers is that they say that once the resolution plan is formulated, you must get a credit rating of RP4. RP4 means a moderate viability and moderate payable capacity of the entity concerned. Now, RP4 is something which is very hard to come by because you've got 2 credit rating agencies which have to give you the RP4 rating, and typically in resolution plans which are approved by the banks, the success is a little difficult because it is stretched a bit too much, and obtaining an RP4 becomes very difficult, and if RP4 is not there, then clearly the plan cannot be approved. After that, of course, there is the equity has to be allotted within the specified period. You have to ensure that all the documentation has to be completed within the specified period. So these are other conditions of the resolution plan which may not be so troublesome. Another issue is the 180-day period itself. People have been talking in terms of this period being a little short, considering the fact that there are certain macroeconomic factors which are also influencing the resolution processes over which neither the bank nor the corporate debtor has any control. And unless these are particularly, let us say, in power as has been considered by the Supreme Court, there is the coal allocation issue, there is the repayment of money from the electricity the authorities. So all these are very substantial macroeconomic factors, and they can't certainly be covered within this period. So even if you take such companies through the IBC subsequently, unless these macroeconomic factors are resolved, there will be no resolution of those cases in any case.
So clearly the issue goes beyond section 35AA, and we are trying to make suggestions to the RBI on how the circular should be worded with 2 experts, Mr. Gandhi and Alok Dheer. But I'm afraid it's time for us to slip into a very short break. Please do stay with us. We'll be back very soon. Welcome back. You're watching Macros with Mythili, and I'm in discussion with 2 experts, Alok Dheer and Mr. R. Gandhi, on how the RBI's Feb 12 circular should be reworded and reworked in order to prevent further litigation on the circular. Mr. Gandhi, as you mentioned before the break, one of the most contentious clauses is a 100% agreement, or all agreeing, as Mr. Alok mentioned, on the resolution process. Is this something that is quite unrealistic, given that these are typically large advances where lending has been done by a consortium of banks, and even if you have one dissenting bank, that's enough to put a spoke in the resolution process. So should this be watered down to a more realistic 66% as in the intercreditor agreement, or should even a simple majority in terms of exposure be enough, Mr. Gandhi?
See, earlier, I think Reserve Bank had put such a condition because at that time, if they don't agree, it has to be compulsorily, mandatorily taken to liquidation. So probably Reserve Bank thought that if you are taking a company to liquidation, then all the debtors will have to agree to that. I think that was the reason that 100% agreement on resolution plan was insisted upon. Obviously, that is impractical. That is certainly granted. So now that the revised circular will not be able to mention about taking the things to liquidation under the IBC process. So this particular constraint need not necessarily be there. Reserve Bank can talk only about resolution plan, restructuring plan. In restructuring and resolution, it need not necessarily be 100%, where majority of the lenders would agree, whether it is 75% majority or 66% majority, that one can always work it out appropriately. So by less than 100 should be possible now to be incorporated.
Alok, in a scenario where we have governments being formed with less than 40% of the vote, this idea of 100% or all or even 66%, is that very realistic? Also, the Reserve Bank of India as a banking sector regulator can actually issue directives only to banks. But as we've seen in many cases in the IBC process, operational creditors can also put a spoke in the wheels. So how do we address that issue as well? So two questions to you, Alok.
To my mind, let me just first clarify, insofar as this 100% is concerned, clearly this was something which was completely out of line and was most unrealistic. It is almost impossible to have a situation where all creditors, and we have some dissenting creditors, and most creditors have completely different security covers. So there would be somebody who would be miffed. As we saw in the case of SR Steel, it was Stancy, and they are still fighting this because they are getting a very small amount of the piece of the cake, but they are financial creditors. So to expect to get 100% consent is almost impossible, and frame rules which are impossible to implement is equally unrealistic. Having said that, even in the IBC, we started off with a super consent of 75%. And over a period of time, it was felt that this 75% is just too much. And it is also becoming difficult to implement. And so it was reduced to 66%. In such a situation, for us to have a pre-IBC with a 100% consent is unrealistic. So that should not have been done in the first place. Insofar as the other aspect that you said, insofar as creditors are concerned, to my mind, it is, insofar as operational creditors are concerned, there is, if you look at it in a very cut and dried manner, in the Insolvency and Bankruptcy Code, they have said the COC will be determinant, and if COC determines, and in fact, if it says that the operational creditors will get no more than what they would in liquidation, then a resolution plan will go through. So that's a very cut and dried way of looking at it, that you don't have a security, you don't have a charge which is superior to the other financial creditors, and therefore this is, if it is not in liquidation, it is almost very close to liquidation, and therefore if this case slips into liquidation, which is the next step after CIRP, and you get nothing, so you should allow the company to survive without having to go into liquidation. That's the concept of that's the way, a very cut and dried financial way of looking at things. But then the economy is run on operational creditors. Just to be able to say that operational creditors will be thrown out of the system will mean that nobody will want to give credit as operational creditor to any corporate debtor. And that itself will bring in, us into a completely different era where it will be difficult to do business altogether. So a mid-ground has to be found.
Mr. Gandhi, another sticking point really is regarding the one-day default. True, a single-day default does not make an account an NPA, and DG Vishwanathan has argued that we need to have the same discipline when it comes to bank lending as in the case of the corporate bond market, where the borrower is penalized with rating downgrades and a higher rate of interest even for a one-day delay. But is that a little unrealistic? Moreover, it's not as if borrowers are not penalized for delays. They're charged overdue interest for the period of delay, and banks can seize their assets, unlike in the cases of corporate bonds, where typically they are unsecured. Mr. Gandhi?
So here the point is not about comparison between borrowing and from the bank and borrowing from the market. That is incidental. But the fundamental position is that when somebody is unable to pay on due date or well before the due date, it means that there is some problem with that account. That both the borrower and the lender will have to be alert, recognize that there are some problems. Is the problem is a temporary one, which will be resolved in a next few days or a couple of weeks, or is it going to be continuing? That assessment, the compulsions or the discipline to make a work on the position, that is what is being called upon by marking it as SMA 0, SMA 1, SMA 2. It is not that straight away, it is, as you definitely said, that it is not NPA yet, that 90 days are there. But during that 90 days, seriousness, is it being called upon on the part of the borrower to make good things right? And the lender also being alert about possible incipient problem that may creep in. So it is a kind of discipline which is supposed to be brought in. So that way there is nothing wrong to set the clock starting from day one.
Okay. Do you agree, Alok? Or is the one-day condition a bit too stringent? Because many borrowers argue that the moment they start, even if it's SMA 0, SMA 1, it makes life much more difficult for them if they go to borrow from outside the banking system. So should we be a little bit more flexible on that one-day requirement, Alok?
this concept of one-day default is actually a early reporting of NPA concept. And the SMA 0 was in fact in place since 2014. So it is not as if it has come into the circular of 2012 for the first time. What it does is that if there is a default, it triggers off two things. Within 90 days from the date of the first default, you have what is called an NPA. So you have the SM 0, 1, 2 and then the NPA. So it's the starting date. It's only defining that from this date. The consequence is if within 90 days it is not rectified, it will become a non-performing asset. And insofar as the circular is concerned, the 12th February circular, it gave the reference date of 1st March 2018 and said defaults either prior to that will be given 180 days, or if a default has occurred subsequent to the specified date, within 180 days. So the default date is the starting point. Nothing is happening on the default date except, of course, it's recorded as a special mention account. But it becomes the starting date for declaration as an NPA, or for that matter under the circular from the date of filing under the IBC. So to my mind, relaxation of that date really means nothing. It is already inbuilt into the system.
So both Alok as well as Mr. Gandhi feel the one-day default is not something that needs to be reworked. But Mr. Gandhi, the problem really with the court ruling is that it has held that all the cases that have been proceeded against in terms of the February 12th circular are non-est. That means do not exist. Since the RBI's new circular presumably cannot have retrospective effect, can the RBI tell the banks to refer these same accounts on their own steam, Mr. Gandhi?
See, RBI cannot tell that, because when we say that it has to be, the banks will have to take their own call, then it cannot, that such a direction cannot come from Reserve Bank that you take your own call. That automatically is the meaning when the Supreme Court has said that the earlier action taken by the banks so far will be non-est. So afresh, the banks will have to take on their own. So that goes without saying, I think. If Reserve Bank would give such a direction, it may be seen as circumventing the Supreme Court direction.
Alok, what is your reading of the situation? Will the process have to start all over again in the case of these accounts then?
Mythili, I believe the impact of the Supreme Court judgment in the Dharani sugar matter, which we are talking about, which says that the petitions under Section 7, which have been filed consequent to the circular, will have to be set aside. Yeah, will have to be set aside. Now, there are going to be very, very few cases where you can identify that this case has been filed under Section 7 only on account of the circular. There is no such mention in the petition. The only what will happen is a lot of confusion will be created. Many cases which have been filed immediately after 12th of February will claim that they have been filed under the circular. Material will have to be placed by the bank on record, and possibly RTI applications will be running around to find out what was the basis of the bank. If the bank's internal working mentions the 12th circular as also a host of other issues or reasons for filing the Section 7, it will not be hit by the judgment in the case of Dharani Sugar. Only if you find that there is some internal noting which is based only on the 12th February circular and says only account of this factor, we would refer this to Section 7, will this case be hit, which to my mind is going to be very, very unlikely, and therefore there is not going to be much issues arising out of this. In any case, even if some case were to be hit by the circular of 12th February, the banks on their own motion, or in fact under 35AA, if the central government directs the RBI, then again it can be filed because it will be in compliance with the provisions of the 35AA.
But Mr. Gandhi, the present impasse will no doubt be resolved once the RBI comes out of the new circular. But does the final solution really not lie in banks being run professionally as commercial entities and not needing a push from the regulator? Because even though the safety of depositor money is important, nowhere else do we see the regulators doing this kind of micromanagement. And especially if the loan is fully provided for, then surely the next course of action should be left to the banks. No, Mr. Gandhi?
I fully agree, because the resolution is of any borrower's account, because it is under default, it should be entirely left to the commercial judgment of the lenders. It is not the central bank's duty or the supervisor's duty to give a scheme under which how that restructuring should be done. The point here is why the Reserve Bank has been giving such schemes all along. It is because banks wanted certain forbearance from the Reserve Bank of India. Certain forbearance in terms of the account being classified as NPA or not NPA in terms of provisioning. So for those kind of facilities, They were asking the Reserve Bank to bring a scheme, and once the Reserve Bank says that if you follow these kind of framework, then I give you forbearance here and there. So that was the purpose for which Reserve Bank was being expected to bring in schemes. That is number one. Number two, where banks were reluctant to settle the cases, like in the case of MSMEs or in the case of agriculture. There again, from the public policy perspective, it was required the central bank to give a particular frame, a scheme like that, of a one-time settlement scheme and kind of thing. So it is for those two purposes, the central bank steps in and gives a direction or gives a scheme. In the absence of scheme, the banks in no way are constrained in terms of restructuring any there. So that way, even today, because even the power companies or all others, they are expecting what? They want certain accommodation to be given beyond the normal standing rules. That kind of rules can come only from the central bank. So that is the point. So why Reserve Bank should be stepping in, or it is asked to, or expected to step in.
Yes, clearly there is in fact a great deal that, many a slip between the cup and the lip, and the final circular will have to be very carefully drafted by the RBI to ensure that the discipline of the IBC process is maintained. At the same time, this endless litigation should come to an end. Thank you so much, Mr. Gandhi, as well as Alok, for joining me in the discussion. Hopefully the senior officials in the RBI listening into the program and the next circular that we see will pass muster with the courts. Thank you also for watching. Remember, we'll be back next week with yet another edition of Macros with Mythili. Till then, it's thank you and goodbye from all of us at TT Now.